Does the law matters? Of course it does. Welcome once again. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters. Because the law matters. Understand the law better, and you're in a better position to decide how to help yourself, your family, and your business. As we present various topics, you may decide, of course, to handle some yourself. We're here to help you do that if you should decide to do that. If you decide to seek outside professional counsel, our goal is to help you be prepared and also to help your counsel be better prepared. Our goal is to, of course, save you time, money, and always to achieve the best possible results. We want to welcome and thank, as always, Attorney David Bizarre from the Bizarre & Associates law firm in East Providence as he continues to present and help us with the various topics that we discuss. Recently we discussed alimony and spousal support. Today, Family Court Part 2. Equitable distribution of assets and child custody, visitation, the ground rules. Of course, the issue about property is always contentious, but of course, when it comes to child custody, that certainly has been known to be among the most contentious of issues and most heartbreaking as well. So what are the factors that impact on all of these decisions? Let's begin with the issue about the equitable distribution of assets as opposed to equal distribution of assets.
Correct, because it doesn't necessarily mean that. So when a case comes to family court and the court has to make a decision on equitable distribution and alimony and custody and all those things, we're actually sort of taking the issues out of order as to how a judge might look at how they need to be decided, because the first thing the judge wants to figure out is usually custody, placement of the children, and all the children issues first. And then, before the judge can do alimony, at least in Rhode Island, they need to do equitable distribution because that can impact the need for alimony depending on how the assets are divided. So now we'll talk about equitable distribution. And I think historically what you need to know is how this whole idea of divorce and family court and all those things developed over the years. Because historically, a husband would always pay alimony to a wife on divorce if there were grounds for divorce, because we didn't have no-fault divorce. You had to have grounds for a divorce. Adultery, behavior wicked and repugnant to the marriage covenant, habitual drunkenness, those were types of grounds for divorce. And the husband owned everything. I think even at one point in time, the wife was considered property. Exactly. Just like the cow, the dog, and whatever else. And so it was the husband's obligation to support the wife, and the wife wasn't allowed to own property, so there was no equitable distribution to the property, maybe dower, the percentage that the wife might get on death, and certainly in a divorce there might be a percentage, but it was really basically husband's property, his obligation to support the wife. Well, of course, that all changed. And the equitable distribution statute was created. And in Rhode Island, what the legislature did first, and what the court has to interpret is what is the property and how do you divide the property up. So the first thing you have to do when deciding what equitable distribution should be is decide what is and what isn't a marital asset. So we can start with that if you want.
So, of course, first thing is whatever you brought beforehand, how does that play out? That can be very sticky.
It's sticky, it's interesting, and it varies from state to state. So in Rhode Island, for example, assets that you had prior to the marriage generally are considered to be non-marital assets. Assets that you obtain by inheritance or gift are considered to be non-marital assets, unless you commingle them and then they are transmuted into a marital asset.
That can become sticky. Tell us how that becomes sticky quickly, or can come.
Right. So if you inherit money and you put it into a joint bank account, it's no longer considered an inherited asset, but a joint asset because it was something that you co-mingled with other assets that belong to the marriage. That's one easy example. Another example, not so easy, is you owned a house prior to the marriage. You had furniture in the house. You and your spouse used the furniture for 20 years and bought some more, got rid of some, and all of that. And is the house a marital asset? Well, you owned it prior to the marriage, so the house itself might not be a marital asset. The increase in value of the house during the marriage could be considered a marital asset. And did the property that you had inside the house transmute into marital assets by the use by both parties of it? Potentially. And there's a case on point in Rhode Island that says that it probably is a transmuted marital asset.
It may be transmuted, but it also might have lessened in value because it's older.
Yeah, well, the property itself, the personal property, you're true, but generally speaking, the real estate usually over a course of time will go up in value.
And if a wife is maybe a stay-at-home mom for some years, maybe wants to go back to work later or whatever, but she might not have directly contributed dollars and cents, but how do they decide how that gets split up when, in fact, maybe the man is still the breadwinner and she's doing what should be a very highly paid job, namely taking care of house and child, whatever? How do they work that out, David?
So the Equitable Distribution Statute says there's a number of factors that you look at in deciding how to divide the assets that we've now determined are marital assets up between the two parties. And the court, generally speaking, looks at these things sort of as a partnership. And let's look at, starting from a 50-50 perspective on a partnership as to factors that may swing something one way or the other. So how property was acquired is a factor. So if the husband wants to argue, because I think you said the husband was the breadwinner and he was working and he was making the money and he wants to say, I'm the one who earned all this money, that's how we acquired all these assets, I'm entitled to more. The statute also says to look at the other spouse, not necessarily wife, but in your hypothetical wife, who stayed at home, and what is her or his contribution as a homemaker, taking care of the home, caring for the children, doing all of those things that would cost money otherwise to hire somebody to do, has an economic value. And so those contributions are also factored in, and generally speaking will probably offset who earned more money.
So are you saying that there's an actuarial element to this? You can assign that homemaking, child care has a certain designated monetary value that we add to the pot when we're dividing those assets?
You could. I think judges mostly do not. I think they look at it more holistically. What was the partnership like? Did both parties contribute to the partnership sort of in an equal fashion? And by taking care of the children and staying home and taking care of the house and cooking the meals and doing the grocery shopping and being the chaperone to different things and the transportation to other things, that's one aspect of what you could look at, as opposed to being out in the workforce, earning money, and maintaining the economic stability of the family. Those are both important aspects. And so if you're both doing those things and sharing in doing those things, it's probably still 50-50. There are other factors still that might be considered, such as the conduct of either party. And now that's conduct both good and bad. So good conduct. I worked hard. I did all the things. I did what I was supposed to do. All right, that's a plus. Bad conduct. I was gambling, drinking, having an extramarital relationship, doing something that caused the breakdown of the marriage. That could be conduct that's bad and negative and takes away from the split of the assets.
And while we talked about this before, even if there is no fault divorce, meaning it's irreconcilable, you're going to get the divorce, no fault doesn't mean that there isn't fault if you participated in some ongoing bad behavior when it comes to divvying up the goods.
The conduct is still an issue in dividing up the assets because it's still one of the factors that the judge can look at in deciding how to divide the assets between the parties.
And what states don't believe in equitable distribution? Is there such a thing? I mean, I understand that there are specific listings of which states are community property. Maybe you should discuss that a little bit, but are there those that aren't equitable distribution states?
Yeah, community property states look at property owned by a marriage differently than an equitable distribution state. And I don't practice in any community property states, and I'm familiar with it, but it's not something that I generally look at and deal with every day. But my understanding is California, I think, is a community property state, for example, that the marriage owns everything, and each party owns everything, and then how they divide it up from there is something that's a little bit beyond what I deal with on a day-to-day basis. But even equitable distribution states can look at things differently. For example, while California says the marriage owns everything, it's community property, Massachusetts and Rhode Island look at what is includable in a marital asset and what's not differently, because Massachusetts doesn't distinguish whether you inherited or got property by gift. It still goes into the pot. And then the statute will look at, well, how do we divide that pot up now? And I would argue that they still should look at where it came from, like Rhode Island does. Where does the asset come from? How did you get it? You got it by gift. It was a gift to you from your parents. They intended it for you. It's part of the marriage. Should that be in your column, so to speak, as we divide up assets?
And of course, while we're not talking about prenups in this particular segment, that I assume could be a factor that, I guess, has some value and
Sure.
brings to bear on when that divvying process comes into play.
That's right. A prenuptial agreement will take a look at, by contract, how we're going to divide everything up. And you are allowed in a prenuptial agreement to do things that the equitable distribution statute doesn't necessarily call for.
And when we were talking about bad behavior, on one side of the ledger, when we might say the stay-at-home spouse, whoever that is, female, male, whatever, might have some dollar assigned to their work, their value. If the one who is out working is the one who has the bad behavior, how do they mince and parse how fault is going to be, I guess, subtracted from their part of the equitable distribution? How does that work?
So I think it depends on what the fault is. And generally speaking, the value assigned, like I said, is not necessarily a dollar figure. It's just, again, I use the word holistic look at the marriage and both parties, what their contribution was in acquiring property, because it's not just acquiring property, but it's maintaining property. So if I was the one making the money to acquire the property, and you were the one who was doing all these other things so we could maintain the property and keep the property and didn't have to spend money that we earned otherwise because of everything that you're contributing, I think those offset each other. So that, to me, keeps us at 50-50. But now the factors of conduct, like I said, it depends. If my conduct was such that I'm out every night, I'm drinking and I'm gambling and I'm losing money, and some of the assets that we acquired are being diminished because of my actions, I think the judge can look at that and say, well, you're not getting 50% of the property that's left. You've already squandered property, signing 40% to you and 60% to your spouse. And the judge can do the same thing for conduct for having an affair, infidelity, that type of thing.
And when people are trying to decide who gets half of the house or who stays in the house, is it the lawyer and the defendant or whomever is trying to draw up the draft of the agreement, who decides whether or not, once they do the 50-50, that 50 shouldn't include part of the house because one spouse can't support it, shouldn't stay in it, no, you should instead sell it? How does that work out, David?
So generally speaking, there's two ways a case can settle in equitable distribution resolved. One way is, well, there's more than two ways actually. One way that it can be done is that the parties can do it themselves. So the parties can just come to an agreement. This is what we agreed to. And then they can go to their lawyers, and the lawyers can tell them, well, you know, you've given away more than you have to, but you're allowed to do that. You can do whatever you want to do. And then they have an agreement, and it's put in front of the judge for approval. The parties may not be able to agree. So another way to do it is the lawyers can sit down with their clients and each other, and we call those a four-way sometimes because there's four parties to that conference, and the lawyers and the parties negotiate out a settlement that is acceptable to everybody, and then it's written down, usually in the form of a marital settlement agreement or property settlement agreement that's presented to a judge for approval. The parties can go to mediation and have a mediator help them resolve that, which then becomes a memorandum of understanding, and then that's turned into a property settlement agreement usually and presented to a judge.
So you were mentioning it might be a four-way, two lawyers,
Two parties.
Two parties. If it's involving those four, is there ever a time when it would then go to a mediator, or is it just that it might begin with a mediator and end up with
It can go either
lawyers
way.
battling?
Yep, it can go either way.
Either way, okay.
In family court, mediators generally don't like to have mediations with lawyers involved,
Yes.
but it's been done
Okay.
on many occasions. It's, that's how mediations work sometimes, so it can be. And of course, I didn't get to the last way it could be done is nobody can agree, and it goes to a judge,
That's the
and there's a
next question.
trial, and the judge decides.
And is that usually the best way to let that play out?
The judge will usually tell you, you don't want this person in the black robe sitting up here who doesn't really know either of you very well deciding what your future is going to be.
Okay, and I guess that's a good place to transition to the other contentious issue. What do you do with the child or the children? Obviously, the court and hopefully the parents always want what's best for the child, but if it's each of the parents, they always, or they might often think, I'm what's best for the child, and that precludes you. So how does that play out, and how do you deal with that?
Those are sometimes the most difficult situations because you can usually figure out a way to divide money. You can't always figure out a way by agreement to divide children.
It's biblical.
Right. And it's the most heart-wrenching because sometimes you want to say to the person on the other side, do you hate your spouse more than you love your children? Because what we're really looking at is trying to figure out what's the best way to resolve this difference and this marriage with the best interest of the children in mind. And the worst thing you can do is argue about it and have that be something that the children are feeling and knowing, and that you guys can't agree. Maybe it's our fault, you don't love us, whatever. And sometimes it's because, as you said at the beginning, that one spouse or the other thinks that they are what's best for the child, which precludes the other. It's never the answer, usually never the answer, because when you can't always say never in family court.
Certainly.
Because sometimes it is the answer, but almost never the answer, that just having one parent is the best for the child. Children need two parents, and generally they're better off having two parents. So what is the motivation? Is it because the other spouse really is so bad and shouldn't be around the children? There are reasons for that. Well, there are, then let's hear them. But if it's just because you think you're better, well, even if you are, that doesn't, what makes you better is that you want the other one to be, the other parent to be involved and to have a role and to support that role and to make the children understand that we're working together for you. So that's the thing. And sometimes one parent wants to leverage the children for other purposes, better equitable distribution, more money. That's even worse, I think, sometimes than the parent who just thinks that they're better.
Do you have to ride shotgun over that if you see someone starting to do that before it gets to the court?
My difficulty as an attorney representing someone is my point of view is I'm always going to want to do what's in the best interest of the child. And you always have an obligation to represent your client zealously. But in my opinion, your ethical obligation in representing your client is also doing what's best for the children, because it's in your client's best interest to do what's best for the children.
And for the record, is it also true that you don't want to go to court leaving it up to the guy with the black robes to decide who gets what part of the child?
Just like equitable distribution, if you can avoid it, yes, that's usually a much better way to do it. And that's one of the things where mediation generally is better than leaving it to a judge to have to decide.
So let's talk about custody. I think that there was certainly a time when it was mom who's going to get the child unless she was just impossible to deal with. Certainly that's changed, and there are things like joint custody, but there's legal custody, physical custody. Let's go through some of those things and how they play out. I believe that they, as you said, they always want to have joint participation. Is that the same as joint custody? So let's talk about that.
So generally speaking, yes. And historically, like we did with equitable distribution, we can talk about it because when I first started practicing, it was assumed that custody belonged with the mom. And that's what they talked about, custody with the mother, and they said visitation with the father. And when I started practicing early on, I had a case where there was a mother and a father who not only wanted to have shared legal custody, joint custody, they wanted shared custody, and in a very interesting way. And I had a judge who had been a judge in family court for a long time, probably since the beginning of Rhode Island family court, and he was the one, you would go in front of until he understood this as life progressed, that, no, the mom gets custody. What are you talking about, joint custody? Well, Judge, this is joint custody, meaning both parties have the right to have input into the education decisions, the medical decisions, the important life decisions. It's a joint fiction, it's a legal fiction actually of joint custody, meaning they both have the right to make those decisions. And he eventually understood that, but what he really had a hard time with was this couple who they decided this is what they want to do. They had a house, and about a mile from the house, they had an apartment. And they wanted to do 6 months in the house and 6 months in the apartment and alternate. And that's how they were going to share custody. And the judge said, I don't know if I can approve that. That's not going to work. Well, Judge, they've actually been doing that for a year that they've been separated. Well, if that's what they want to do, I'm going to approve it. But I'll tell you, it's going to work until one thing happens. What's that, Judge? Until one of them meets somebody else. And then they have the second spouse syndrome, I think he called it. So I don't know, they never came back, so I think it worked. However, I understood what he was saying. So generally speaking, we start with custody. And we now, instead of starting with sole custody, we generally start with joint custody. That doesn't mean placement. So where's the placement going to be? And once the parties decide placement, they can have shared placement. We do cases with shared placement all the time. I don't see any cases really where we're alternating who lives in the house and who doesn't, but we do see placement where it's 7 days with one parent, 7 days with another, 3 days with one parent, 4 days with the other, and then 4 and 3. Many different ways to share that placement.
But how can that work? Well, it can work as long as they live in the same area, but suppose that even if they live in 2 different towns, that's going to impact on how that child's going to get back and forth to which school and when. And certainly that gets very complicated. Never mind if the next year someone takes a job in another state and all the rest of it, as it can compound.
It only works as well as the logistics will work.
Yes.
And it can work, as you said, you don't have to live in the same town as long as you designate which parent's town will be the home for school purposes.
Yes.
But yeah, if I live in Cranston and you live in Providence and the school's in the middle, we can drive back and forth, it's fine. So it can work, and it does work for many, many people. But once you've decided that, well, maybe placement is with one parent, then what we need to figure out is, well, what's the other parent's parenting time? I don't like to use the word visitation anymore because a parent shouldn't be visiting with their children, they should be parenting their children.
Point well taken.
And so we try to resolve parenting time, which can include not only weekly, but holidays and vacations and summer and all of those other issues that need to be decided as to when the child is going to be with which parent.
So if it was once that mom got custody, now you're saying it's joint. Is that still true if you have an infant? Or will they then still move more towards mom who, I'm not saying mom's nursing, but other than that.
But so there used to be a doctrine called the tender years rule, and it would say if an infant is, bonding with the mother, the infant should stay with the mother. It's more difficult if you're right, if the mother is breastfeeding and it's that young, and those issues are still very important to the nurturing of a newborn. But if there are other reasons not to, It's more difficult, but as the child gets older, it can be one or the other, and not everybody has to deal with that issue, and there is pumping of the milk that the father could take and have spend time, so there's ways to do it, and it depends on each individual situation and what's going on that either the parents should look at or the judge.
And if you're saying that the goal, of course, is to have joint custody, then how does that impact back on that equitable distribution issue? So if one parent has all of the responsibility, financial, emotional, mental, whatever you want to call it, then they might have the scales tipped in their favor a little more to help offset that financially.
Well,
how does this play out, or maybe it doesn't?
Not really.
Okay.
Because there's child support still
Yes,
that
okay.
needs to be calculated and paid, and if there's one parent who has, even joint custody is not going to affect that, it's placement. So
Okay.
if I have like full placement or full custody, if you will, joint custody just meaning that both parents get to weigh in on important issues and have the right to talk to teachers and doctors and those types of things. Sole custody, the other parent doesn't get the right to talk to a doctor or a teacher. And sometimes there's a reason for that, but generally it's not. So it's the placement of the child, and now what will weigh in on equitable distribution in that situation is if one parent is going to have primary placement of the children and they have a home that's reasonably affordable and the children have lived there for a number of years, you might want to keep the children in that home till they graduate from high school or if to some certain event happens. And that could be considered, in Rhode Island we call it a deferred sale of the marital home. And you might say, all right, I'm going to pay this for child support. I'm going to contribute towards the mortgage, taxes, insurance. And at the end of whatever that period of time is, the house will be sold and the proceeds will be split then.
And when it comes to custody, how often do you have the judge asking or someone asking the child who he or she would prefer to be living with most of the time?
Yeah.
How often does that come into
So
play?
we try to avoid that because you try to avoid having the child put in the middle of a situation like that. But sometimes it has to happen. And sometimes people will come in and say, how old does the kid have to be for them to talk to the judge? And so here's what we try to do first. You might appoint a guardian ad litem, which is another lawyer, to represent the child's interest and to speak to the child, not to bring the child into court, to have to go into a back room to speak with a judge, with a stenographer present and in some like difficult setting for the child. If that won't work, some judges will speak to the child, and I think that they should because sometimes you don't need it filtered through another person in the right circumstances with the right child. And so generally speaking, if a child is older, what does that mean? 13, 14, 15? Certainly 13, 14, 15, probably old enough.
Sounds good. We hope that this has been helpful to you if you should have to deal with equitable distribution of assets or child custody issues or other family issues. Stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.